Mr. Harper, we proceed with you this morning.
Yes, Milady pleases. Milady, I was at page 44 of our heads of argument, and I was about to commence the fourth issue, voting irregularities. At this point, I'm going to have to trouble the court to refer to the actual underlying documents, because I think this is the best way of dealing with the topic, to look at what the documents actually say against the background of what the witnesses have stated in their affidavits. So the starting point in this inquiry is Annexure LD 5, which is at page 353 of the index papers. If the court is with me at that reference, page 353, the crucial paragraph is paragraph 1, pre-conference processes. It states timeframes must be set towards the conference. These timeframes should take into account the following sub-processes. 1, verification of membership. 2, status of branches. 3, corrections and amendments. 4, allocation of delegates. 5, convening of BGMs and BBGMs. 6, verification of constitutionality of BGM. 7, correction period. 7, running of political education and preparation before conferences. And then the final one is 70% qualifying branches in brackets minimum. Now the case is made out in the papers for the respondents that the 70% qualifying branches minimum is a requirement that applies to all of the preceding listed items. And that the mistake that was made by the applicants is to assume that those requirements were all cumulative and that they weren't all governed by the 70% qualifying branches minimum requirement. As a result, the applicant's case was not structured in founding to take into account the impact of the 70% rule, and they proceeded as if one lone complaint would be sufficient to set aside the entire conference. And that's where the parties part company as regards the 70% rule. Mr. Zikalala explained the 70% rule in the document that was drafted by him, which is SZ5. And if I can trouble the court to turn to index pages 1147 and 1148. And at 1148 in paragraph 2, Mr. Zikalala revisits what is stated in LD.
Just one minute.
For the convenience of the court, we have set out the relevant extract at page 46 of our heads of argument, paragraph 165. And Mr. Zikalala has explained that this document was accepted as binding, his explanation, and that it came about before the 8th provincial conference in question. And if one reads it, it states, quote, the ANC conference is an outcome of logical steps in a process seeking to ensure organisational readiness, maintenance of legitimacy and integrity of such process. Such pre-conference processes have to meet the time limit set for each of the following steps, and then he then again lists the steps: verification of membership, status of branches, corrections, etc. And then there is the crucial concluding sentence at the foot of page 1148, which reads as follows, quote, The conference is convened if there is a minimum of 70% branches that have successfully completed all steps in the pre-process for the conference. And we know that, in fact, the 70% rule was followed in relation to this particular conference, because we have a report of the National Working Committee to the National Executive Committee on November the 27th to 29th of 2015, and that appears at index page 1362. And that document records that at the last NEC meeting, this is in paragraph 5.1 of that document, a decision was taken to allow the eThekwini Regional Conference to take place, held during that weekend, and the Provincial Conference to be held during the weekend of 6 to 8 November 2015. So in passing, this answers a question I was asked yesterday about who actually made the decision and who had the power to make the decision for the Provincial Conference to go ahead, and it is very clearly the National Executive Committee, not the Provincial Council itself. And then over the page at 1363, there are also some very important paragraphs, in particular paragraph 5.2, which reads, quote, "The PEC decided to continue with the Provincial Conference as scheduled, as 70% of branches were in good standing. This was complying with the constitutional requirements of the minimum of 70% of the branches being in good standing." And then there was a note 5.3 that the NEC now and in future should discuss this minimalist approach of complying with minimum requirements instead of ensuring that as many branches of the ANC have access to the conference of our movement, quote, so that members of the ANC can benefit from debates and discussion taking place in conferences. And then 5.4, both the PEC and the NEC deployees insisted the conference be allowed to continue, and it was then allowed to go ahead. This was after the officials of the province engaged the national officials. And then it's recorded after the conference.
Just repeat the page you're referring to.
This is page 1343, index page. 1343. And then 5.5 is important as regards context. It was recorded that since the conference they have witnessed protests and a flood of appeals against the proceedings and outcomes of the conference. This is in line with what we reported in the NGC of conferences being appealed by groups that do not win. This trend and tendency has to be confronted by the leadership, as it is the newest form of destabilization of our movement. So what do we know from this? We know, firstly, that it was the NEC that approved the conference. Secondly, that they applied the 70% requirement, as it was explained by Mr. Zikalala. And thirdly, they put a flag so as to possibly discuss this minimalist approach in future and whether it was what they all really wanted going forward. But for the moment, and this is the important point, it was accepted that the 70% rule applied. And in the respondent's submission, that applied both in relation to the initial quorum to allow the conference to go ahead and as regards the conference taking place eventually and being finalized. Because on the respondent's version, the way that it works is this, is if there is 70% compliance, then the conference goes ahead. If people are dissatisfied with a ruling that has been made that leads up to the 70% minimum being met or exceeded, they are not without remedy. Their remedy is to lodge a complaint and follow the appeal process. If the appeal process is successful, then they're allowed to participate in the conference. If the appeal process is not successful, then obviously they aren't allowed to participate in the conference. This is a structure that they have agreed to in advance by becoming members of the ANC. They have no reason to complain about it, and they also have no reason to deviate from it or to bypass it. So the result of that on the respondent's version is that if, for example, you get 71%, you beat the 70% minimum. But let's say there are a number of appeals, and the appeals reduce that figure to 69% by the time the conference date arrives. Then the conference can't go ahead because the 70% minimum has been breached. If, however, there's 71% and there are many appeals, and it then doesn't disturb the 71%, then the conference can go ahead. So that's how complaints are contractually stipulated to be dealt with, and must be dealt with as part of administrative law that applies to this voluntary organisation performing a public function. So that's the respondent's case. There are a host of documents, even documents adduced by the applicants themselves, which reflect the application of the 70% rule over a wide range of different regions and in respect of a wide range of different branches of the ANC. It's also applied in relation to regional conferences as opposed to provincial conferences, and the reference to that is at page 364 of the index papers, which is an extract from LD6, which was part of the applicant's case. And there's a problem with LD6 that we've dealt with in the papers, and the correct version is SZ1. But be that as it may, what is stated here is the region should have launched at least 70% of the potential ward-based branches in the region. In relation to the previous conference, as part of the documents, there was a table summarizing the 70% rule applied in respect of all of the regions for the 2012 conference. And that appears in the document SZ4 at index page 1146. I'm sorry, my lords and ladies, to jump around in the documents, but it's unavoidable for this part of the case. So at 1146, if the court is with me at that reference, we have what is described as a table which presents the membership statistics and branches per region. And then we have the various regions listed in the left-hand column, starting with the lower South Coast, and then it goes right through to the Tequeni region, and then there is a total reflected at the extreme left-hand column. And in the next column, which is headed wards, we see that the total number of wards is 828. And then the third column very crucially reflects the 70% figure. And the court will see that in respect of each of the regions listed, there is a number. For example, Lower South Coast, 59, and it has branches in good standing, the next one, and then branches not in good standing, wards without structures, and then the final column is total verified membership in good standing. But one will see that the 70% rule was applied in respect of each of those regions. We've also given the reference in our heads to a number of other regions, in particular the Moses Mabhida region, and all these references are in fact in the papers. So there's no doubt that this was something that was applied. In the report on the state of readiness for the 8th Provincial Conference, and that is in Annexure SZ6, the 70% rule is also reflected, and it states that the province had already reached the 70% according to the preliminary audit.
does that appear?
My reference is at page
1156, is it?
1156.
But is that the stage that it should apply, 70% at the preliminary audit? Shouldn't it be that one really looks at the 70% rule after all opportunities were allowed for appeals, etc.?
Yes.
So it shouldn't really be done on the preliminary audit.
Yes.
It should be done after an adequate opportunity for objections and any irregularities complained of, as you said, being dealt with in terms of the contractual remedy provided in the Constitution.
Yes.
And only thereafter do you really apply the 70%.
Yes, quite correct. All Mr. Zikalala was doing at this stage was saying that the preliminary report indicated that the province has already reached the 70% of branches. So it does also apply, however, at that stage, because the conference, there must be a decision made as regards whether the conference is to go ahead at a certain stage. So they do look at it at the preliminary audit stage as well. But yes, my Lord Justice Kun, we agree that it's an overall standard that must be applied at the end as well. A good example appears in relation to the 70% rule as regards how it was applied in respect of the regional conferences. And that appears at page 1340, which is SZ8. And if the court is with me at that reference, paragraph 3.2 deals with the position. It says, quote, the province is proposing that the regional conference be held not later than December 2015 to allow the organisational structures to lead the local government elections campaign. Up to the weekend of 31 October to 1 November 2015, 22 branches had held BAGMs and are therefore in good standing. 22 out of 60 do not meet the threshold of 70% for holding a regional conference. This requirement will have to be met for the NEC to decide to hold such a conference. There are equally strong views that we should not rush to the conference. So that's what would have happened if the numbers had dropped below 70% in respect of the provincial conference. The conference would not have gone ahead. It would have been aborted at that stage. So the applicant's case, as it is formulated in the answering affidavit, appears at page 1075 of the papers, in particular paragraph 324. And I can do no better than quote that, and this is what Mr. Zikalala says. He says, quote, firstly, the applicant's complaints in this regard do not go to the first bullet point under paragraph. Firstly, the applicant's complaints in this regard go to the first bullet point under paragraph 1, entitled Pre-Conference Processes in Annexure LD5. And this, of course, applies also to the timing issue, because those are pre-conference processes. Mr. Zikalala says, quote, namely that entitled Verification of Membership. As I've also pointed out, all of those pre-process conferences are subject to the 70% rule. Put differently, as long as 70% of the branches in the region meet with the pre-conference processes, then the conference can proceed. The remaining 30%, no matter how valid their complaints, cannot prevent the provincial conference from proceeding, nor can they complain afterwards if it does. And Mr. Zikalala explains elsewhere why the 70% rule came about. And it is for obvious practical reasons. In a conference of this size, involving this number of people, there are inevitably going to be problems. It is inconceivable that any election process can be run without some problems emerging. So how do people deal with this on a practical basis? Is it practical to say there has to be 100% compliance with every single process? Or do they set a reasonable benchmark in advance and contract that if there is that reasonable benchmark, then there is a valid conference? Put differently, and this is not a concept that is unknown in our law, has there been substantial compliance? And the ANC have decided for itself in advance that substantial compliance means 70%, and that was achieved in this case. We turn now to the next aspect dealt with in our heads of argument, and that is the complaints as to the founding papers. So I'm not going to go in detail into our submissions from the previous point up to page 59, but we of course abide by all of those submissions. It's instructive at this stage to have regard to what were the complaints in founding, and those are summarized quite conveniently by the applicants in paragraph 52 of their founding affidavit at pages 36 to 38. And it is helpful, I submit, to refer to that at this particular point. If the courts are with me at that page, paragraph 52 reads, "The grounds for seeking the aforementioned relief will be dealt with in greater detail below. For the purposes of this summary, I state that the complaints fall broadly into the following categories." And they then set out categories 52.1 to 52.10. In other words, 10 categories of complaints. And an analysis of that reveals that most of them are actually not persisted with at the level of the present argument. And why I say that is that the detail of what is in those categories is dealt with in the founding papers. But that detail largely centered around an annexure L22, which contained particularity of the individuals that were involved and the individual complaints. All of those complaints were thoroughly addressed in the answering papers, and they have been defeated at least by the application of the Plaskon-Evans rule. And this appears to have been conceded by the applicants. So out of those 10, the only ones that we can currently recognize are as follows. 52.1, and that is the Rule 17.2.1 debate as regards the 1/3 branches. And then paragraph 52.7, which is the alleged failure to give branches any or sufficient opportunity to query and correct the various pre-PC audit findings in breach of the audit guidelines of the party. And that goes to the timing issue. And that appears to be it. If we can go through them briefly, 52.2, that relates to the detail of delegates who'd allegedly not been mandated, and that was dealt with in relation to LD 22. The manipulation of membership numbers, also dealt with. Manipulation of PC voters' roll, also dealt with. Exclusion of bona fide delegates, also dealt with. Recognition of delegates from non-qualifying branches, also dealt with. Failure timeously, regularly to respond and rule upon complaints, that was not really much particularized, but has been dealt with. And then the alleged failure to give recognition to delegates legitimately nominated by ANC branches, that was also dealt with. And then the failure to postpone the holding of the PC conference, while various complaints were dealt with, has also been dealt with. So,
After 52.9, the complaint about certain appeals having been dealt with and branches qualifying, but then on the accreditation not being recognized, does that not fall under 52.9? The point made yesterday by Mr. Madonsela towards the end of his argument.
It may be correct, looked at it with hindsight, but if one looks at the detail, the particularity that was in the founding papers, this particular complaint that is raised now by our learned friend Mr. Madonsela, based on Mr. Hunt's heads, appears nowhere in the papers. And it's easy to see that it doesn't, because the comparison that they're drawing are between two SZ documents, and the SZ annexures were put up by Mr. Zikalala, and they weren't present at the time of founding. So they're not part of their founding papers, and as far as we are able to see, they weren't even canvassed in reply. They raised as a newborn argument in heads of argument. And the result is that there's no factual detail dealing with that, because the comparison they attempt, if I can just deal with that briefly to contextualize.
Sorry, I didn't want to take you out of your line of argument. I was just in trying to identify what the complaints are. If you're going to deal with it later, then fine, deal with it later.
Yes.
If it's
I may as well deal with it now, my lord, just to contextualize it, because it's obviously a well-grounded question that needs to be addressed. The complaint, as we understand it, that's now made is you have the appeals process, and there's a record of the appeals decision, and that should be the same as the people in the updated credentials list, and they've drawn attention to some discrepancies in those. But what's missing there is any explanation for that, and a number of possible explanations may spring to mind. And secondly, what is the significance of that? The real significance of that can only go to a person being deprived of voting. And they can only say that a person has been deprived of voting rights if they look at the final voter's roll. And if we can imagine we all go and vote in national elections, hopefully, and presumably, and you get there and there's a long list of voters' roll, and there's an official there that checks your ID, and they see that you're on the voters' roll, and then they tick that you've either voted or not voted. So for that argument to have any traction and sustainability, it would have to be linked with the deprivation of a voting right. And without the final voters' roll, that argument gets nowhere. It's a non sequitur, because they can't show that anyone's actually been deprived of the right to vote. And that would be something that would be a material complaint. But they can't show that. All they can show is there's some discrepancy between the appeals record decision that was adduced and the updated credentials list. And we just don't know what happened in the meantime, because it's never been cancelled and canvassed in the papers. So that point, just to contextualize it, we submit actually leads nowhere. It's simply a pointing out of an apparent discrepancy that has no traction and no sustainability as an argument. So we back then to, on the papers at least, just two arguments. And the first one I've dealt with, that's the 1/3 branches debate. So I now turn to the other one, which is 52.7 relating to timing. Now, at this stage, it's necessary to take a step back and understand the context in which the complaint is raised. The complaint is raised at the level of a pre-branch general meeting complaint. And the complaint centers on two aspects. Firstly, the so-called 5-day requirement, and secondly, the so-called 2-week requirement. Now, if I can deal with those in turn, the 2-week complaint relates to the branch membership role. And the complaint there is set out at index page 74, paragraphs 107 and 108. If I could trouble the court to turn, please, to those pages. They say, as is clearly apparent from the National Conference guidelines, after the preliminary audit, branches are supposed to be given a proper opportunity to verify and correct any errors or disputed items arising therefrom before proceeding to hold their pre-conference BGMs. As is apparent from Annexure LD5, the guidelines recommend that the voter's roll as ascertained during the preliminary audit be furnished to the branches 2 weeks before the BGM date to ensure that all members have been correctly captured. This recommended period is clearly intended to ensure adequate time for disputes and objections to be investigated and properly determined so as to achieve an accurate branch membership roll prior to the BGM. And then they say in the next paragraph that each of the applicants is a branch executive committee. None of the branches received the branch membership roll as determined by the preliminary audit 2 weeks before the date set for the BGMs. The time frames in respect to those branches from rolls being furnished to the holding the BGMs varied from about 4 days to the roll only being furnished by the regional deployees at the commencement of the BGM. None of the regional officers in question called the relevant BECs as they should, etc., and they go off into another complaint. So the complaint there links to what is in a guideline, which is not stipulated to be an absolute requirement. And it also links to the time that they were in fact allowed prior to the holding of their BGMs. And we can see that the applicants link that to LD 16. This is at page 16 of their founding papers, paragraph 99.2. They say, under LD 16, branches were at best afforded the period from 6 September to 11 September in which to challenge and correct the preliminary audit report and branch rolls before the BGMs commenced on 12 September 2015. Again, I appreciate that not every branch had its BGM on 12 September 2015, but the point is that those branches which were scheduled early in the BGM calendar were severely prejudiced by the short time for corrections. So that is their allegation, and if one looks at those LD timelines, they are contained at page 402 of the papers. And there is a table there that says membership verification, branches to confirm audit report 6 September 2015, and then 2 rows after that, in other words, the third row, reads corrections and appeals to allow branches to effect corrections and improve their status 10 September 2015. So there we have the 4 days about which they complain. Now, that document is the same timeline as is set out in LD7, which provides the context in which it was given. Now, those are the timelines for the November dates that actually occurred. And what we can see from LD7.
What's its page reference?
364.
Sorry, it's not LD7. It's SZ6. I beg your pardon. SZ6 is at page 1155 and 1156. If the court is with me at that page, page 1155 is a page of a document drafted by Mr. Zikalala. It's a report to the national officials on the state of readiness for the provincial conference of 2nd of November 2015.
Is there significance in that? Because in fact there wasn't one on the 2nd of November, it was a little bit later.
No, there's no significance in that, my Lord. I think the date simply...
Because the actual conference was from the 6th.
Yes, sorry, it's the 6th to the 8th of November, but I think the report was given on the 2nd of November.
So the heading is to that extent just wrong.
The heading is ambiguous, yes.
It was contemplated to be the one of the 6th.
Yes. We can see that from page 1156, the final row says convening provincial conference to convene provincial conference, 6-8 November 2014. But the significant part that I wanted to refer the court to is under paragraph 2, headed state of readiness, and it's the second paragraph in that document. And it reads, quote, the PEC developed a roadmap which spells out organizational and logistical tasks which are required in preparation for the provincial conference. The following is the roadmap towards the provincial conference. And there we have the same details about which the applicants complain. And that is the membership verification, 6 September 2015 to 10 September 2015. But there are 2 points that are of the utmost significance. The first is, as should be apparent from what I've already stated, it's no more than a roadmap. It's not an inflexible setting of time. And secondly, the same document reveals that, in fact, the time for the holding of the bar general meetings was extended for a period of approximately 2 months. And that we see from page 1156 under the heading convening of B/BAGMs. The fourth paragraph reads, quote, according to the time frame, all branches should have convened the BGMs by the 25th of October 2015. However, after consultation with the Secretary General, it was agreed to push the time frame to 1 November 2015 to accommodate more branches, especially from the eThekwini region. So the roadmap time frame was accordingly extended. And why it was extended requires an understanding of how the branch general meetings are convened and held. As I said yesterday, the Provincial Council does not stipulate the date by which branch meetings should hold their BGMs, other than stipulating a cut-off date. It's up to the individual branch executive committee to decide on the date that they want. What that means is if they feel that they need more time to deal with a particular issue, then they can simply adjourn their branch meeting to another week, a week later or 10 days later or 2 weeks later, in order to give them more time to deal with an issue such as that which they have. There is not a single appeal that was ever proceeded with on the basis of too little time to verify.
The extension given there was a week.
Well,
page 1156?
yes, but it was in relation to...
I thought you said 2 months.
Well, in relation to the time period that the applicants talk about, 6 September, it was 2 months. So what this records is what happened in the past. In other words, he says after consultation it was agreed to push the time frame. So it's not just a week's extension, the Lord, with respect as we read it, it records an historical fact that this was pushed to the 1st of November 2015.
Would have been from the 12th of September to the,
well, the 10th of September to the 1st of November. In other words, if branches felt that they were being prejudiced by too little time, it lay within their own hands to set another branch meeting date which would allow them sufficient time. But none of them felt prejudiced in any event, because if they had felt prejudiced, then they would have appealed on this basis. And they never did. There's no record of any such appeal. So we have a situation where these 4 loan applicants complain about a shortage of time that their branch executive committees have never complained about and never pursued by way of appeal. So that links back to what we submitted yesterday. How is it possible that these 4 loan applicants who have contracted for a certain procedure and for someone else to, their representatives, to pursue the appeal process, they can somehow bypass all of that, breach their own contract, and come to this court and say you must set aside the entire provincial conference when we ourselves have not followed our agreed procedures? And if they're suing on contract, it's a fundamental rule of contract that where it involves reciprocal obligations, you must first perform your obligations before you are entitled to claim that another party is in breach. Now, the applicants, of course, much of timing arguments at present in argument, but in their founding papers, they merely described these timelines as proposing timelines. And that appears in the founding papers at page 65, paragraph 91, where they deal with the particular document, and it talks about proposing timelines. So again, on their founding papers, one searches hard for anything to say that this was something that was set in stone from a timing perspective. And the respondents, in dealing with this in their answering affidavit, have stated that the 2-week recommendation was just that, a recommendation and not a mandatory requirement. And that appears at page 1076 of the papers in paragraph 327, where the respondents comment on those allegations by the applicant. And at paragraph 326, the respondents state that the recommendation referred to by the applicants, this is the 2-week recommendation, is culled from page 3 of Annexure LD5, where it is contained in the 3rd row of the column to the right of that page, and the introductory words to that table are significant. Quote, tabulated hereunder are certain procedural challenges that in attempting to host a successful conference. It is recommended that the following primary principles are adhered to, then such challenges may be averted.
I was going to ask you about that, Mr. Harper. If you contrast what's at page 354, what you just quoted us at page 354 of the papers, to what appears at page 1150 as part of Annexure SZ5, there's a difference in wording. And the latter, forming part of the respondents' papers, couched in more peremptory terms. Page 1150, also under the heading of key common challenges, also starts off tabulated here under are certain procedural challenges. Sorry. One says procedural challenges, the other one says common challenges. But that's not the part I want to refer you to. The next sentence, it then says, before dealing with the 2 weeks requirement, the following principles must be adhered to, as opposed to it is recommended. Does that change your argument?
Just
1150.
which annex shows that?
Annex SZ5. The second sentence, before the columns.
We would submit not, my lord. There is an apparent change in language.
No, it's not a recommendation anymore. It
Yes.
says must be adhered to. But you say it's the same. It's not a
Yeah,
preemptory.
there doesn't seem to be any intention to make it mandatory, but linguistically there may be a difference there that should be taken into account. But either way, we say that it matters not, because whether it was mandatory or not, more than the 2-week period was given. And it lay within the branch's power to deal with the situation if they wanted to extend their branch meeting date or to appeal.
I understand.
In relation to the 5-day complaint, if I can turn to that now, the complaint is dealt with by the respondents at page 1079. At page 339. Now, that is SZ1 that Mr. Zikalala is referring to, which is the National Audit Guidelines. And the provision is that the National Audit Team will provide the relevant Provincial Secretary with a copy of the preliminary audit report, and then the branches will then have 5 days within which to raise their queries. So that argument would track along the same lines. Again, it relates to a pre-branch general meeting procedure, and it lay within the hands of the branch executive committee to extend their dates if they felt that they were prejudiced by any short time, and they were given a longer period anyway, and there are no appeals based on that. So that, my lords and lady, we submit, in essence, comprises our submission on the timing arguments. We submit with great respect that they do not withstand scrutiny, whichever way one looks at them. And we have dealt with those submissions in more detail at pages 59 onwards from our heads of argument. And in particular, we submit that the complaints are not well founded when seen against the history of how the conference came about. There was a good reason for holding the conference earlier, and it was well worked through the provincial structures and the National Executive Committee structures. And we say that, according to Mr. Zikalala, the former provincial chairman, Mr. Senzo Mpunu, started the call for the provincial conference. And that is dealt with at page 60, paragraph 212 of our heads. And then I'm not going to take the court through the subsequent history, but it's summarized in our heads at pages 60, 61, 62, 63, 64, 65, and 67. So we say, with respect, that the applicant's version regarding the timing, that this was all a rushed, ill-advised conference, is not factually correct. It's not a realistic and fair assessment of what happened, and the submission is that the applicant's contentions in this regard, to the contrary, are exaggerated. And there is no, in fact, valid residual complaint regarding the timing of the provincial conference. The point is also made in paragraph 264 is that what actually happened is that the branches were involved in the audit process and accordingly came to know of the audit findings as a result of that involvement. The preliminary report was given to Mr. Zikalala as the Provincial Secretary. It was also communicated to those branches that had been disqualified as a result of the audit report. And that version, with respect, should prevail on the Plascon-Evans test. And it's borne out by the probabilities of the matter that there was never an appeal on the basis of this alleged timing problem. And surely if the branch executive committees had been dissatisfied with the timing, they would have complained and they would have appealed. And in paragraph 265, we refer to the hearsay evidence which forms part of the applicant's case in stating, indeed, in most cases, the branch officials only discovered the status of their branches, etc. They don't give any details as regards which branch officials are referred to, and the same applies in relation to their other allegations that in other cases delegates from branches which had held successful BGMs were told they did not qualify, etc. So we say that the applicant has two problems evidentially. Firstly, their case is defective in that in crucial respects it relies upon hearsay evidence, and secondly, we have the direct evidence of the respondent which prevails by virtue of the Plascon-Evans rule. The other point to consider is that the conference went ahead and there's no record at the conference of any complaint regarding timing, that there was too little time given for the pre-BGM processes. And the credentials report was presented at that conference and it was accepted by the conference. So all of the contractually and constitutionally stipulated processes were in fact followed and successfully so. And we have a situation now where 4 lone individuals who are disgruntled with the outcome want to complain afterwards. There was some criticism against the respondents reflected in the papers for failing to produce the final voters' roll, and the explanation has been given that the respondents could not produce something that they did not have in their possession. And that document was in the possession of the relevant official from the Independent Electoral Commission that was involved, and it cannot be located, notwithstanding attempts by the respondents to obtain that. And with respect to the applicants, they are expected to come to court with a case that is proved both at the level of pleadings and the evidence. They have no entitlement to come to court and demand that the respondents must produce documents that prove their case for them. They have given no explanation as regards why they have not gone direct to the Independent Electoral Commission and tried to get the voters' verification roll themselves. They simply choose to otherwise attempt to shift the blame onto the respondents, which in the circumstances is unjustified. So that, we say, deals with the situation regarding the timing complaint. We now turn to the sole surviving complaint, and that is in relation to the apparent difference between the appeal result and the final accreditation process. And I've addressed the court already in substance on that issue, and we maintain that it's simply trite law that one cannot argue on facts which do not appear in the papers. As regards the notion that people affected in the appeal document outcome or in the final accreditation credentials roll must be consistent with the people who actually voted, there are two problems with any such notion. Firstly, we don't have the final voters roll. Secondly, there may be many reasons why a person who is accredited to vote does not actually vote. The voting would take place at a certain time on the conference at a particular day. A delegate could, for example, come to the conference on day 1 and be indisposed on day 2 if the voting was going to take place on day 2. So it may be that he just wasn't there to vote. So one has a limited ground for obtaining traction to say, well, there's a discrepancy between this document and another document, and why was this discrepancy in relation to voting?
Yes, but all of that could have been resolved had the voters' roll been before us.
Yeah, it could have been resolved, but the unfortunate fact of the matter is there is no voters' roll, so the court must, with respect, decide the case on the available evidence. Yes. As for the rest of our heads, we remain with those submissions. I don't submit that it's necessary to deal with them in the exact detail. I would like, however, to highlight certain aspects that have arisen, in particular, firstly in relation to the submissions made by Mr. Ngu Kaitobi. One of the points that emerged in the debate regarding the 1/3 of branches was what was meant by at least. And according to the Oxford Dictionary, at least means not less than, at the minimum. And we say that some meaning must be given to those words. So it's a minimum requirement, it's not a maximum requirement. Secondly, in relation to the point as regards what constitutes an empowering provision, we have overnight revisited the relevant provisions of PADJA, and there is in fact a definition section in PADJA which deals with empowering provision. And that reads as follows, quote, empowering provision means a law, a rule of common law, customary law, or an agreement, instrument, or other document in terms of which an administrative decision was purportedly taken. So I emphasize the words or an agreement, instrument, or other document in terms of which an administrative decision was purportedly taken. It is not limited, we stress, to a law being a statute law or a rule of common law or customary law from the definition itself. Our learned friends rely upon the judgment by Mr. Justice Wallace, as he then was, in Sokela. If one examines that case, two things are apparent. Firstly, Mr. Justice Wallace held that one of the decisions was in fact administrative action, but the other wasn't. But that case was decided within the context of an entity which was not a political party. Political parties have a peculiar public function. Equally, the decision in the Calibra clinical consultants case is distinguishable, as I indicated yesterday, as it relates to a bargaining council, not a political party. There is no record in Ramakatsa of anyone contending that the actions of the ANC did not constitute administrative action. The third leg relied upon was expressly on PADGA, and there's no record of anyone saying PADGA did not apply. The court in paragraph 61 merely said it was unnecessary to consider the claim under PADGA, but that, as submitted yesterday, was because of the state of the law at that stage, as it was pre-CETA versus Gajima. And the court itself emphasized the public nature of political parties in paragraph 64 to 69. And if I can trouble the court to turn to that, it's in our extract of documents, because it casts some significant light on the notion of what is and what is not public and a public function. In fact, it starts at paragraph 64, where the Constitutional Court draws attention to the unfortunate history of our country, where the majority of people in the country were denied political rights, and they lay emphasis on this fact as providing an important context as regards the role that is occupied by political parties. And in paragraph 66, they say, paragraph 65, in the system of democracy, political parties occupy the center stage and play a vital role in facilitating the exercise of political rights. Paragraph 66, they say, in the main, elections are contested by political parties. It is these parties which determine lists of candidates who get elected to legislative bodies. Even the number of seats in the National Assembly and provincial legislatures are determined by taking into account available scientifically based data and representations by interested parties, etc. And then paragraph 67, in order to enact multi-party democracy, the Constitution has enjoined Parliament to enact national legislation that provides for the funding of political parties represented in national and provincial legislatures. Public resources are directed at political parties for the very reason that they are the veritable vehicles of the Constitution has chosen for facilitating and entrenching democracy. And then paragraph 68, they draw attention to the fact that unlike the past electoral system that was based on geographical voting constituencies, the present electoral system for electing members of the National Assembly and of the provincial legislatures must result in general in proportional representation. That means that a person who is intended to vote in national and provincial elections must vote for a political party and not for the candidate. And then crucially this passage, quote, it is the registered party that nominates candidates for the election on regional and national party lists. And then in another paragraph, according to my notes, it is paragraph 17, the Constitutional Court emphasizes the importance of the present inquiry. They say, if it turns out that the appellants are right in their allegations, the political party in the whole of the province will be governed over the next 4 years by an irregularly appointed provincial leadership. And the size of the political party is not necessarily decisive. Suffice it to say, the political party we are concerned with here cannot be said to be insignificant. The importance of the requirement that members of political parties should not be governed by an irregularly elected leadership cannot be overemphasized. Now, the point that is raised is what's the point of all these references by me? And the point is twofold. Firstly, it's an inherently public process that the political party is engaged with in going ahead with a provincial election. because of the proportional representation system, those persons who are recalled as a result of the election and the new people who are elected are the persons who are entitled in turn to elect the members of the legislature, the members of government. It's not the individual voters who do so, it's the political party itself. So it stands to reason that when they call for a provincial conference and when they decide to go ahead with the provincial conference, it's an inherently public process, and that constitutes administrative action. The fund sales case we submit is the most clear in this regard, and what happened there was an individual was recalled, and we say that our facts with respect are stronger than those in fund sales case, because here we have a whole provincial executive that will be recalled, and all the proportional representation appointments made in consequence for that. So fund sales case is not distinguishable as contended for by the applicants on the basis that it's a mere internal procedure. It's an inherently public process. And that can be demonstrated by two annexures that have been adduced, SZ2 and SZ3. If I can trouble the court to turn to those. SZ2 is at page 1119 of the index papers. And this is addressed to all regions from the Office of the Provincial Secretary, and it's from Mr. Super Zuma. And he states the Provincial Secretary has received the attached letter from the Secretary General's office requesting regions to submit 3 names of the mayoral candidates in order of priority to the Provincial Executive Committee. And then follows the list, which is an annexure, which carries on from page 1120 onwards. And one can see, just looking at the first of those rows, Lower South Coast Region, Ugu District, and then there is the name of Mondli Chiliza and a contact number, and then Amdoni, Mzumbi, Umuzi Wabantu, Ray Nkonyeni. All of the names of the mayors are put forward. And then annexure SZ3. That commences at page 1122, and it's the Provincial Deployment Committee report. It says the Provincial Deployment Committee held its meeting on the 7th of August 2015. No apologies were reported. The following principles were outlined and unanimously agreed upon. And then follows a table for the Lower South Coast region, and one can see there the deliberations that take place regarding the appointment of the various municipal officials. They deal with the deputy mayor, the speaker, and the chief whip in the Ugu district, and then in the various other districts as well. So that is a graphic illustration of the knock-on effect and the public nature of the process. The submission was made by the applicants in relation to the delay, that there was an undertaking by the President himself to come back within 5 days. A reference to the founding papers with respect reveals that that submission is somewhat overstated. if we can have a look at the page, according to my notes, it's page 106, paragraph 165. What the deponent says, the applicant's deponent, is as follows. Paragraph 165, he says, the members of the delegation from the NEC were the President, Mr. Jacob Zuma, Jesse Duarte, Joe Pashla, the Secretary General, Gwedi Mantashi, Baleka Mbeti, SABC, Skawacha, etc. And then he says, paragraph 166, once the branches had presented their cases to the delegation, they were advised that they would receive a decision within 5 days. However, no response has ever been received by those branches. In fact, the ANC has remained silent notwithstanding this exercise. Now, two things we note from that. Firstly, the President is not singled out in the averments to say he specifically said that. So with respect, it's a little unfair to contend that that is in fact the case. And this is a well-publicized case, and what is said in this courtroom is rapidly reported elsewhere. Secondly, the deponent, in fact, makes it clear that it was the ANC that was to come back, as represented by that particular committee. And they do, in fairness to them, say that they didn't get a response by, after the expiry of 5 days. But what they are silent on is why they didn't then immediately respond on day 6 and say, where's our response? We want a response. They were content to deal with the matter on a leisurely basis, and they only addressed a letter then during May 2016. And then they got a letter back from the Secretary General, and then they did nothing for a further couple of months until they launched the application.
Sorry, Mr. Harper, 5. That's the annexure SZ13, the minutes of the NEC meeting. And
Yes,
it says in relation to KZN that the NEC endorsed the outcome of the KZN Provincial Conference and recommended that a task team be established to investigate and address all complaints arising from the conference. Is that not the same?
Yes, but it could appear to be so. Sorry, if I can have the page reference again?
1425.
Yes, Lord, it could well be.
So at least at that level, speaking for myself, it conveys the impression that there was going to be a task team assigned to investigate these complaints and presumably come back.
Yes.
And that was as early as 29th or 27th November 2015.
Yes, that is correct.
Yes.
The investigation was ultimately done, of course. We know that from the supplementary affidavit that was delivered by the respondents, and if I can refer to that, it's at, I don't think it's an index page yet, but it's in our application to supplement the papers.
Yes. What page of that affidavit?
It's an annexure, SA2. Now this is 1st of September 2016, and it reflects that there were objections received from a number of branches as contained in an attached report, which was submitted, the complaints were submitted after the announcement of the results of the conference. And Mr. Mantashi says in paragraph 4 that the complainants are objecting to processes they participated in, including acceptance of credentials. in the conference. And paragraph 5, he says the value of the report, which is attached, is attendance to the queries raised and attend to weaknesses identified to strengthen the organisation into the future. And then he adduces a document which is a summary of processes at eThekwini.
Yes.
And in there he records not as truth, but at the level of these were the complaints.
Yes.
So we know from this, my Lord, that the complaints were taken seriously,
Yes.
that were raised after the conference, they were investigated, and they were flagged for dealing with in future.
So when was this report made available? His letter on SA2 is dated the 1st of September 2016.
Yes.
And that, as I understand, would have been after the date when this application would have been instituted.
Yes.
Yes.
There's no certainty as regards when the report was made available, but what it does reflect is that the complaints were not simply ignored.
Yes.
So someone took notice of the complaint, and the complaints, each and every one, and they took care to tabulate what they were in respect of each region.
Yes, no, I understand,
Yes.
Mr. Harper. The only reason for my question is I understand your argument in this regard goes to the delay in the institution
Yes.
of the application.
Yes,
That's
yes.
the only purpose for me
Yes,
asking.
yes, I appreciate that, Lord. The other context, of course, is that this was not a mandatory process. There's nothing in the Constitution that provides for an appeal process post a conference. It's like the national elections. The national elections give a particular result, guaranteed not everyone's going to be happy with it, particularly the parties who remain in opposition. But they have to accept the result of that. So at the level of was there an appeal process that should have been followed and it was unduly delayed, that argument doesn't get out of the starting blocks because there is in fact no appeal process. All that can happen is that the ANC can listen sympathetically to complaints that are raised post an election and flag them for dealing with at a future stage. So to the extent that the applicants may have expected anything different from that, they were wholly misguided. All that they could hope for was a sympathetic ear to their problems with a view to rectifying things in future. And it was a hopeless mission that they were on to try and have some sort of non-prescribed appeal process to set aside the result of the provincial election. It was never going to happen.
But is it a sorry, continue.
Yeah, and they ought to have realised from day one, and in fact, according to the authorities, they should realise from day one, which is the date of the election process, if they had a complaint then, that's the date that the clock started running, to do something about it with a court process, because they had nothing else. So it's no excuse for them to say, well, we had a whole lot of complaints ad misericordiam, and then we spoke to people and they didn't come back to us. It's nothing other than a complaint and misericordiam. It goes no further than that. It has no official status whatsoever. And it's not as if their complaints were ignored. They were in fact dealt with. And I'm sorry, Mruda.
No, you carry on.
The other interesting aspect of this recordal of the complaint is, as far as we're able to ascertain, there's no recordal in this document of the complaint that the applicants now argue. And there's no complaint about the comparison between the record and the updated credentials report. So with respect, these are complaints. The present complaints that they persist with are, with respect, manufactured complaints for the purposes of litigation.
Well, I don't know whether that's entirely correct. The SA2 letter in paragraph 4 records they were objecting to processes they participated in, including acceptance of credentials in the conference. But that wasn't really my question. Your submission might be entirely correct in regard to the calculation of the 180 days, but undertakings of a task team being set up, etc., would surely be relevant in determining what is reasonable for the purposes of any other common law. which has to be brought within a reasonable time.
Yes.
You made your submission yesterday about a 180.
Yes.
The case that says, as soon as you know, you can't say I don't know about the facts and rely on that.
Yes.
But
Lord,
it'll be different for
yes,
reasonableness.
we readily concede it's relevant, it's a factor, but it's not conclusive in our respectful submission.
Yes.
It doesn't go to the overriding obligation to bring the matter to court quickly. And just as much as any party is perhaps to be commended for engaging in settlement negotiations to avoid litigation. But
You can't complain if your claim's prescribed.
Yeah, the prescription clock still ticks in the meantime. And it's advisable to conduct both in tandem, we would suggest. There are a few other
Mr. Harper,
minor...
I think we'll take the short
Yes,
agenda
Admiral,
at
please.
this point.
What do you think? But
And she looks apparently close to reports. Perfect. Yeah, the court closed at 4, so it was comes to shop. But I doubt it is to be fair. Thank you so much for your bye-bye. Hello. Thank you. Bye-bye. So my colleague asked me about Amanda, yeah. So we decided we wanted to receive her. And I told her the editors. That's very so we didn't have some time. So the office, one of our editors, it's all as we say that our partners, they order like a few questions. The way we do it, one of the things tells them, so I'll pick it up as often. But I think they give I think probably Yeah, I'm giving you for around that. But I'm not going to list the case because we have a colleague who is from out of 5 regions, 4 have gone, well, 1 didn't go, 1 that's right.
Say something.
You see him there, they came to the festival, walking down.
But the legs, you know what the legs were?
I love
Because yesterday, what's it?
I am treating that. Who's going to NTZ tomorrow? And who is this place? Just where's the one? I could actually see you annoyed. I could actually see you.
I know you were pissed off yesterday. It's like,
He's still pissed off today.
he's always generally angry.
No, but I see him. He's like, no, he could not. He's like, ha, 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 ha. No, not him. No, I'm like, you're lying. He's like, oh, no.
Lies.
That's life.
Oh, yeah, I don't know about
I look at you, buddy. Look at you, buddy.
No,
As the court pleases, I have only a few remaining points by way of catch-up points. The first is our learned friends rely upon section 12.1 of the ANC Constitution as authority for the proposition that the National Executive Committee can set aside an election itself. And
Maybe let's just hold on for a moment because people have not respected that court has started. Can we have silence, please?
So you said 12.1.
yes. In other words, their argument there rests in the general power afforded to the National Executive Committee as the highest organ of the ANC between national conferences and has the authority to lead the organisation. But that is only subject to the provisions of this Constitution. And there is no procedure in the Constitution for setting aside an provincial election itself. Paragraph 12.2 sets out some of the specific powers, admittedly not a closed list, but if there was such a drastic power to set aside an actual election, one would expect it to be included in that list. Rule 12.2.4 affords the National Executive Committee the power to suspend or dissolve a PEC where necessary. But that is only within the context that the PEC is not performing its function democratically and effectively, which are the preceding words. There's no power given to dissolve a PEC because the NEC may think that it should be done on the basis of setting aside an election. And it would be surprising if such a power existed because it would intrude into the authority of the High Court. And the High Court is the authority who would be expected to rule on competing submissions as regards whether an election is valid or not. And it would be very surprising to find such a power, and we would submit that it is a very improbable argument to contend that because of the general power afforded to the NEC to lead the organisation, subject to the provisions of the Constitution, that there is somehow a power afforded to set aside the entire election. And it would be undemocratic to do so, we would submit, because then the NEC would be double guessing the choice of the voters.
As I read the Constitution, it provides a lot for sort of decentralized autonomy.
Yes.
Am I correct in that?
Yes, subject to the overall direction by the NEC.
Yeah, administrative, but there are certain things that it can't do.
Yes, certain things it can't
Hence
do.
in 12.1, subject to the provisions of this Constitution.
Yes.
And it's very much a decentralized, bottom of the pyramid, branches, regions, provinces, with a lot of autonomy.
Correct. Yes, so we would submit within that context, it's highly improbable that such a power existed, least of all without some prescribed internal appeal procedure. And in the applicant's founding papers, as we understand it, they concede that there is no prescribed appeal procedure post an election. And if there's no prescribed appeal procedure post an election, how would it be then that the NEC would have the power summarily, without some prescribed procedure, simply to set aside a provincial election? Our learned friend, Mr. Madansela, to move to a different point, made something in his argument of annexes RA2 and RA3, which appear at pages 1598 1599 and 1600 of the index papers. Now, if one has regard to those documents, there is a comparison between the respondent's final credentials and the applicant's updated credential report. That is obviously something different from the argument that is raised in Mr. Hunt's edge of argument regarding the comparison between the appeal record decisions and the updated credentials. And then at 1599 is a comparison between the final credentials and final audit report. That is also something different from the argument raised in Mr. Hunt's case. Nothing much is made of this comparison RA2 and RA3 in the applicant's affidavits. They are put up for the first time in reply and are dealt with in a single paragraph at page 51.3 at page 1564 of the papers, which reads as follows, quote, "Moreover, whilst the respondent's credentials report and respondent's final audit report ought to tally, they do not. In this regard, I have endeavoured to compare both reports as depicted in the annexure hereto marked RA2. So there's no theory that is advanced, even at the late stage in the replying affidavit, that this is somehow relevant to the appeal process and appeal findings not being reflected in the updated credentials report. So this doesn't provide any factual purchase for the new argument which is raised in Mr. Hunt's heads. The final topic, and the court may have to be patient with me in this regard, is in relation to the tweet. My opening remark with respect is that it's probably unnecessary to go into this topic, but it has been raised again, somewhat surprisingly, in oral argument, and we are duty-bound to deal with it, although in our respectful submission, it's not necessary on a proper analysis of the papers. The answer that was set out by the respondents appears at pages 1104 to 1106 of the index papers. And the respondents say that the applicants referred to a tweet which supposedly disclosed the result before the official result was known. The total number of votes on the tweet is recorded as 1459, which corresponds with the actual number of votes cast, but the breakdown is in Nkunu 675 and for Mr. Zikalala is 789, and there were spoiled ballots of 4. Accordingly, the figures reflected in the tweet are not entirely accurate. Mr. Zikalala says the tweet was not from an ANC Twitter account, and it is accordingly, as far as the ANC is concerned, a fake tweet. At best, it does not represent a true outcome of the voting, and it's not backed up by any sustainable evidence. And Mr. Zikalala says, quote, "It is mischievous of the applicants to attempt to rely upon it."
Just a moment, Mr. Harper. I'm going to request the court orderly to request some silence outside this court because it is distracting. And if we can get the aircons on this court. Where is she? Oh, Leela, please attend. Leela? Leela? Just get them to put the aircon on too, please. There has to be some respect for these proceedings inside. Yeah, proceed.
Can I proceed?
Yes.
Thank you, Milady. Mr. Zikalala says that the actual results report, which is referred to under Annexure SZ14, Mr. Zikalala does not know the source of this fraudulent and mischievous tweet. He denies that it is any indication of fraud, and he repeats these allegations. To the extent that the applicant's notion is that the respondents fraudulently predetermined the outcome, yet still tweeted about it beforehand, in Mr. Zikalala's view, this is plainly absurd on many levels. The applicant's allegations are also internally contradictory because if the voting process was still ongoing at the time of the tweet, then no one could have known what the final outcome was, still less tweeted about it. Furthermore, the notion that an independent agency such as the Electoral Institute of Southern Africa, which is the 39th respondent, could have been party to such fraudulent conduct is also not only absurd, but in Mr. Zikalala's words, highly defamatory, not only of ISA, but all of the applicants' responsible officials. He's been advised and respectfully submit that qualified privilege only goes so far, but we needn't go into that. The respondents do not accept that the tweet was sent at the time which appears on the tweet, namely 2200 hours 23 on 7 November 2015, since any details could simply have been inserted in the fraudulent document. The tweet could easily have been manufactured after the event once the actual results were known and done ineptly so that the votes themselves were incorrectly recorded. He submits that it's pointless to speculate in this regard because there's no sustainable admissible basis for the tweet and the entire set of allegations forced to be disregarded, save as it may justify a punitive order for costs against the applicant. He also points out that the respondents' attorneys attempted to follow up to request further details regarding the tweet, and he annexed the respondent's attorney's letter in that regard and a response from the applicant's attorneys indicating a lack of further information. How was this dealt with in reply? The answer to that appears at page 1592 of the index papers, and the response is set out in paragraph 127. It states that the averments are merely noted. Save as is consistent with our founding papers, they are denied. It is stated there's no getting away from the coincidence between the numbers and the final result, but the applicants now say, quote, aside from emphasizing the disquiet which it caused, we cannot take that feature any further. If the deponent reads the paragraphs carefully, he will note that no, quote, allegations, close quote, of fraud are made. It is merely remarked that it was perceived as an indication of possible fraud. On our understanding of what is stated in reply, the applicants have effectively backed off from their allegations, and they do not say that there is any indication of fraud on the part of the ANC or anyone else, and they say that in fact they made no allegations of fraud in the first instance. It's merely to be perceived as an indication of possible fraud, according to them. So the whole inquiry again comes to zero in our respect for the
On Plascon Evans, there lies the answer.
Exactly. Those, Lords, constitute the submissions that we make in relation to the points arising. And sorry, just the only question that remains is one in respect of costs. We do not make any submissions for counsel. We only have 2 counsel. Our opponents, with respect to them, have 4 counsel, but they very reasonably restrict themselves to 2 counsel. We respectfully agree with them that a case of this magnitude and complexity does merit the involvement of more than 1 counsel. So we have no objection to the proposal that either way the costs should be those consequent upon the employment of 2 counsel, being senior counsel and junior counsel. Those are our submissions. If there is nothing further arising from the court, then we propose to stop addressing, save for any new matter that may of course be raised in reply, in which case we may have the need to join issue in that regard.
Thank you, Mr. Harper. Thank you.
As a court, please.
Maybe we're not, Mr. My job will start with this part of the argument in reply.
Sorry.
Yes,
Thank you, my lady.
proceed.
May I commence? Thank you. It's just waiting for the signal from the bench. I want to deal with the reply in themes, and I've identified 4 themes. So perhaps the starting point is just to clarify what we say in relation to the status of the documents. The legal position, in other words, the status of the instruments that we rely upon, the legal position appears in the Ramakatsa judgment at paragraph 79. And that's where the court finds that the constitution of the ANC, its guidelines, and the other rules are binding as part and parcel of this comprehensive contract that is concluded between the ANC and its members. So that's the legal standard against which one must measure the instruments that we rely upon. So the Constitution, as a starting point, would clearly fall within that matrix of the contract. The Congress guidelines and the audit guidelines will clearly fall within that matrix. And the court will find the Constitution at pages 232 to page 268. It will also find the Congress guidelines at page 316, and it will find the audit guidelines at page 1113. So those three instruments that we rely upon clearly are covered within the matrix of the contract, and therefore they are binding. What remains is the status of the memorandum at page 1147, and in relation to the question of what constitutes a legitimate ANC conference. We would submit that it is also binding.
Sorry, what was the page number, please?
1147, my lord.
Yes, thank you.
So we would submit that it would also be binding because the category that is considered to be binding by the Constitutional Court is not limited to the Constitution and the guidelines. It also extends the reach wider to include other rules. So it would be binding as other rules that are envisaged in paragraph 79 of Ramakatsa. So that is the status of all of the documents that we have relied upon. But there is another, perhaps more fundamental reasons why they must be bound by them. This is a voluntary association. When it makes pronouncements to its members in relation to what is expected on branch executive meetings and in relation to what is expected of provincial executive conferences, those undertakings should be taken seriously by the members, because the members, of course, have got certain rights that inhere in them because they have joined this political party. It should not be open to a party such as the ANC first to tell members that these are the rules of the game, and in the middle of the game to turn around and say, we are sorry, we are not bound by the rules of the game. So by virtue of the membership that the members of the ANC have taken, and by virtue of the fact that these are undertakings given to members, that on its own we say that would be a fundamental breach of the entitlement and the privileges that inhere in a person simply on account of being a member. The fourth reason is what appears in the all-pay judgment. The court will remember that case about all-pay. One of the reasons why the Supreme Court of Appeal found against all-pay was that it held that what was called a bid circular was not binding because it was an internal document. And the court will remember that the bid circular prescribed the number of members that would sit in a bid adjudication committee. In that case, it was 6. But on the facts, the number of people that sat in the bid adjudication committee was 4, which is less than, I think it was 5, which is less than the prescribed number according to the circular. The SCA found that because it was an internal document, the circular could not be binding, and therefore the department was entitled to depart from it. But when the matter came to the Constitutional Court, paragraph 38 is of vital importance because it addresses the very point that because it's an internal document, you are entitled to depart. And this is what they hold. SASSA issued the circular establishing a bid specification committee, a bid evaluation committee, and a bid adjudication committee, and their competencies in terms of Regulation 16A-62. It also issued the request for proposals in compliance with its legal obligations under the constitutional and legislative procurement framework. There is no dispute that it did so in a legally proper manner, and here is the point. The circular and the request for proposals read together with the constitutional and legislative procurement provisions thus constituted the legally binding and enforceable framework within which tenders had to be submitted, evaluated, and awarded. So what we say here in reference to all pay is that the memorandum read together with the guidelines and the Constitution created the legally enforceable framework within which the point. I don't want to spend time on the locus standi point. I think the answer is quite clear that individual members are entitled to institute proceedings where they complain that their rights as members of the ANC have been violated. What then remains is the PAJA point. My learned friend has referred this morning to the definition of empowering provision in PAJA. We concede he is right on the definition of empowering provision in PAJA. We don't pursue that point. What remains in relation to PAJA are two aspects of the definition. The first is the requirement of public power or public function. This is the question Justice Chetty asked of my learned friend. What is the public power or the public function being performed in this particular instance. Now, what is crucial, I've got your Paja. If I could steal my learned friend's copy of Paja. What is crucial in the definition, he's permitted me. What is crucial in the definition of administrative action are the following words. In 1B, it's clear they're relying on 1B, not on 1A, because 1A is for organs of state. What is crucial in 1B is a natural or juristic person other than an organ of state when exercising a public power or performing a public function in terms of an empowering provision. That article, when, is so crucial because what it does do immediately is to explain that there are some times when a juristic person performs a public power, and there are other instances when it does not perform a public power. This is why the references to the Ramakatsa and the references to Van Zyl have to be put in their context. When does the ANC perform a public power? Van Zyl tells us when the National Party wants to withdraw a public representative from the legislature. In that context, it is exercising a public power because the entire scheme of removal of a public representative from parliament is governed by the constitution itself. So the ANC cannot take a decision in breach of the constitution. But here is the trick. When the political party acts in relation on a horizontal level in relation to its members, qua members, is it exercising a public power there? And this is why the question by Justice Chetty was in fact on point, which is what is the public power or the public function being performed here? What we see here is there is no public power being performed because this is the conduct of the ANC in relation to its members. It is a conduct entirely governed by the contract that has been concluded between the ANC and its members. It is not the kind of public power that would implicate the ANC in a different capacity, in other words, as a government. And this is not the power in issue here. My learned friend refers to the knock-on effects that by virtue of one's election, they somehow assume authority and power, but they assume no authority and no power in relation to government. They assume no responsibility in relation to the legislature. It is only when they are elected into the legislature that they then become public representatives. Their election purely into the Provincial Executive Committee of the ANC has no public dimension whatsoever. They simply get elected as members of the political party, and that is where it ends. If subsequent to that election, they then take further decisions, such as the recall, and my learned friend uses the term recall, but this is not a recall. It is simply a replacement of members of a political party, qua members of a political party. It is no recall of public representatives sitting in the legislature. This is why one should start with the actual phraseology when exercising a public power or when performing a public function. So the submission is this. When the ANC elects its own representatives, it simply acts as a political party in relation to its members. But of course, when it purports to withdraw those people that have been elected, like premiers, or those people that are serving in the legislature, when those are replaced, of course, it has now entered the realm of public power. Now, that's the first distinct element in this case. It is the capacity in which it is acting. The second distinct element is the question that Justice Chetty asked, what is the public power and what is the public function? What my learned friend ultimately resolves and restricts himself is by saying, well, they have the capacity to affect public power and they have the capacity to affect public functions. But that is simply not the inquiry here. The inquiry is a restricted inquiry. At the time of the election, what kind of power were they exercising then? And so that should be dispositive of this entire debate about whether or not PAJA applies or doesn't apply. But yesterday, I tried to persuade the court that the correct way to approach this debate is not to enter into the morass, because we are entitled to institute these proceedings under Section 19 of the Constitution. Our learned friend says, no, you are not because of Kijima. I have now gone through the case of Kijima last night. With respect, I want to submit that our learned friends misconstrue the significance of Gijima, and it is entirely distinguishable from the case that we are dealing with here. It is distinguishable first on the facts of Gijima. What your lordships and my lady will pick out from Gijima is that what was at stake at Gijima was that an organ of state, SITA, concluded a contract without complying with the tender specifications. Years after the contract is concluded, presumably because of a change of leadership, they no longer want the contract. They then bring proceedings to review and set aside their own decision by an organ of state. They then, in that context, try to get out of Paja and use the legality principle. And the judgment from paragraphs 33, 35, 34, and 35 makes this point clear that an organ of state that wants to review and set aside its own decision should not be allowed to chop and change its course of action. If Paja applies to the conduct of an organ of state when it wants to review its own decision, then it must comply with Paja. What the case on the facts did not deal with is what we are dealing with here. Rights that are conferred to individuals directly by the Constitution. Rights that are conferred to my clients by Section 19 of the Constitution. The closest case to the facts that we are dealing with here is Makanya, the case I referred to yesterday. I've now made copies of the Makanya judgment because we didn't have copies yesterday, and with the permission of the court, I could hand these up. They don't have to be considered now, they can be considered in due time. But to just make sure that the court has copies of the judgments. That's a good question. Yes. Now, what your lordships will see from the judgment of Makanya, Makanya is close to the facts that we are dealing with here because of two primary reasons. What happens in Makanya is an individual employee has got statutory rights that are conferred by Section 23 of the Constitution, the right to fair labor practices. But they also have other constitutional rights flowing from Section 33, the right to fair administrative action of the Constitution. They then approach a court to enforce a Section 23 rights. The law prior to Makanya was that they should be stopped from trying to enforce those rights because if you have a right under Section 23, you must then use a Section 23 right and you cannot use a Section 33 rights. That's the first issue that is crucial. Because if our learned friends are right, what this would simply do is it would simply to confer us with a right under Section 33, not in substitution, but in addition to our rights under Section 19 of the Constitution. And those two rights do not clash with one another. They are supplementary and complementary to one another. This is precisely what happens in Makanya. You have a right under Section 23, and you have a right under Section 33. What should the court do with that? Should the court non-suit you because you have an alternative cause of action? Justice Nugent ultimately resolves the point in paragraphs 62 to 65. And he explains the jurisprudential basis why he came to that conclusion. At paragraph 62, he says, the approach, and he criticizes the approach in the court below for non-suiting an applicant. The approach taken by the court below has the effect of denying to Makanya, as a matter of judicial policy, the ability to pursue the present claim at all, thereby thwarting the assertion of the right upon which the claim is founded. That cannot be correct because judicial policy to that effect would be unconstitutional. Then paragraph 63, it is not unknown in history for authorities to attempt to subvert the assertion of rights by the expediency of denying the holder of a forum in which to assert them. For a right without a forum in which to enforce its right might as well just not exist at all. The drafters of the Constitution were clearly alive to the stratagem of surreptitiously negating rights in that way, which it outlawed by guaranteeing every person a forum in which to prosecute any legal claim, and not only some of them. That guarantee is fundamental to the preservation of rights. And then if you look at what they then continue to say in paragraph 65, clearly, a court may not thwart the assertion of a right by denying access to a court in which to do so. it would be no answer to say that it really will not matter because the claimant has another right that is just as good. If the claimant asserts two rights, and this is not an issue in this case that he does, then he must have a forum in which to be asserted. That is what the Constitution guarantees. To the extent that the objection was upheld on this basis, the order cannot stand. So not only do we get an authoritative statement of the law, but we get a fundamental constitutional justification for it. My clients have got rights under Section 19. According to our learned friends, they also have rights under Section 33. But they have not pursued the Section 33 rights, they have pursued the Section 19 rights. Justice Nugent tells us that it would in fact be bad for judicial policy to adopt the approach that you can close the door in the face of an applicant. On the stratagem, he calls it a surreptitious stratagem that has the effect of negating those constitutional rights. So we submit with respect that the court should not fall into this idea that in effect is about thwarting my client's ability to pursue their claim in a forum of their choice on a cause of action that they have chosen. The true question we submit with respect is whether or not my clients have established the cause of action on the facts. It is not about whether or not my clients should have a door of a courtroom shut in their faces as the ANC respondents seek to do in this case. Now, what then that does is to take us, we submit with respect to the next question. So we would submit there, it's quite clear, the Gijima case is distinguishable, Makanya case is on point. But I made a submission yesterday as well that this is not the first time this issue has arisen in a similar context. We see this in Ramakatsa. Paragraph 10 of Ramakatsa, Justice Yakub finds that there are three causes of action. A contractual cause of action, the Section 19 cause of action, as well as a review under Paja. What they then do, Justice Yakub and Justice Froneman, is they examine the review, in other words, the Paja review. They find that the Paja review is baseless and they reject it. But then they dismiss the entire case. This is the point at which Justice Motseneke starts his judgment, which then became the majority judgment, where he says, what is wrong with the minority is that they have pigeonholed the case to Paja. And because Paja has not succeeded, therefore they have dismissed the entire claim. He says in paragraph 129 and paragraph 130, that is wrong because the applicants had two alternative causes of action. They had a Section 19 right, and they had a constitutional right as members, a contractual right as members of the ANC. And then he goes on to decide the case based on those two remaining causes of action. So this is precisely where we are here. We've got strong authority from Makanya for the proposition that this entire Paja debate is actually a distraction. And we have strong authority from the Constitutional Court that tells you that whatever the views are on Paja, as long as a client like mine has a right under Section 19 and as a contractual right, the doors of the court should be open to listen to the merits of the claim. Otherwise, one simply falls into this trap that, well, I'm simply deciding the law, when the substance of what you are doing is to prevent a party from coming to court. And if one has regard to the entirety of the arguments that are made by our learned friends, our clients couldn't even go through the NEC. They now cannot even come to court. And so you can now see why this is a surreptitious stratagem of negating rights. So, my lord and my lady, it's quite clear that we are entitled to be in court and we are entitled to raise the points that we have raised. What that then remains is the next two questions that I want to address briefly. The first question is, under Section 17(2)(1) of the Constitution of the ANC, a lot of water has gone under the bridge in relation to that debate. What is now clear, even on the respondents' version, there was no 1/3 that asked for this. They say, well, it was a decision of the NEC that permitted the conference. Of course, if there was no NEC, there's the next question, if there was no 1/3, could the NEC have taken such a decision? Justice Kuhn, you asked an important question to my learned friend. The idea that the NEC has got this all-embracing power without limitations is clearly contrary to the constitution of the ANC itself. What is clear is that, yes, the NEC has these powers, but those powers are limited by the constitution of the
12.1 says subject to.
Precisely. We would submit that even the power of the NEC that is being asserted first does not appear in 17.21, the power to authorize the convening of the conference. That power is itself restricted to the power of the branches. And this is the point, I suppose, Justice Kuhn, you were alluding to when you said this is a decentralized structure. The branches decide on the 1/3. Then, if that 1/3 exists, the NEC must endorse. It cannot be the other way around, that the NEC can decide how many conferences there should be. Those conferences are prescribed in the Constitution. So the structure of the decision-making is that the NEC must obviously satisfy itself on the facts, and this will be a pure factual inquiry, whether or not there is a 1/3, and if they are satisfied that there is a 1/3, then of course they have no discretion, because the qualifying term is shall. So if the NEC has any power to call the conference, it's restricted. So once there is a 1/3, it's obligatory. It's not as if they have a choice once there is a 1/3 not to call a conference.
Provided it's a provincial conference that's more than once.
Precisely.
Yeah.
Provided that it's more than once. Yes, precisely. Now, so that is
the wording is more often than at least once.
Yes, provided it is more often than at least once. So the point, insofar as our learned friends seek to suggest that for as long as it was called by the NEC, it was okay, that is wrong, because it could only be called by the NEC more than once if 1/3 of the branches had permitted the NEC to do so. And the role of the NEC is not discretionary here. It's purely a factual exercise. They look at whether there is in fact a 1/3. Of course, if there is no 1/3, they're entitled to reject them. But once there is a 1/3, the rule is they must, if they shall. So they have no choice. And if they refuse, and this is the suggestion made yesterday, that they have a power to refuse, of course they can refuse, but that refusal will be unlawful. This is as simple as that, because they have no power to refuse under the Constitution. Now, the next question on this point relates to how one computes 1 year. Now, here there are two debates. One is my computation, that the 1 year starts from May 2012 and then it ends in May 2016. And there is Justice Kuhn's perspective that the year is the entire calendar year, and as long as the conference was held during the course of 2016, that would have been sufficient. Now, I want to suggest, Justice Kuhn, that we've done some research on this topic. There is a judgment, incidentally, from Durban, but it's an old judgment, 1961, but it's recently been endorsed by the Supreme Court of Appeal on computation of the term year when used in statute. What does it mean when used in statute? So we've made copies of this judgment, which I beg leave to hand up. It's called For Shear and Another versus Mutual Fire in General. Thank you. Oh, no, I think I gave the judges my copy with my notes. I hope there's nothing offensive in those notes. If I could just replace that with a clearer copy. Yes. The relevant is in the second page, starting after view parallel citation. And so they first talk about it was common cause and it is settled authority that the 2-year period, and this was a prescription provided for in section 11, has to be calculated by applying the ordinary civil method of computation. And then if you go, skip the paragraph and you start with the words applying. Applying this method of computation to the 60-day period referred to in section 16 to 11(2)A and 11(b)(2), Act 29 of 1942, the date upon which the claim is sent or delivered constitute the first day and must be excluded. And then it goes on, applying that to the present case, these are the important words, 4th July 1968, the date of delivery of the claims is to be excluded, and the 60-day period commenced at midnight the night of 4th July 1968 and ended at midnight on the night of 2nd September 1968, the last day being 2 September 1968. And then they continue talking about days. But what is clear from this authority is that the computation of a year when used in the statute is from the only issue is the exclusion of the first day and the last day. But the year quite clearly is the date, the month, and the year. It is not from January to December. It is from the specific month or the period when the computation begins. Now, that seems to have been the law, in fact, still is the law, because there is a later judgment that we found called Absa Bank versus Snyman. And I can give the reference from SAFLI. It's 2015 ZASCA 67. And the relevant passage there appears in paragraphs 12 and 15 and 16. So we will submit with respect that what should be applied in a case such as this is what is called the civil method of computation. The civil method of computation clearly applies from the day and the month. Then 4 years would lapse, and then from that period on, the next 4 years would be applicable. Especially when the instrument in question simply refers to year and doesn't tell us anything more. That is the default position. Of course, as the Foshia case says, there might be instances where the context of the instrument requires that it should be read differently. But we know nothing about the context of this particular instrument that would require that the civil method of computation should not apply. So, Justice Kuhn, to come back to the question you posed yesterday to me, which I think I was probably unable to fully answer. The answer is, our proposition is that the year began in May of 2012.
When in May?
I will have to check the...
After the last day of the 7th conference?
After the last day of the 7th conference, yes. That would be the first day, and then the next day would have been again in May 2016. If that is right, in relation to that issue of the computation, then it is quite clear that there were 6 months too early. If this is wrong, and that the way to compute it is to take the generous approach that is implied, even though not decided in Ramakatsa, which is the year is January to December, they were still 7 months too early. Both of those propositions lead us to the inevitable conclusion that what they did is to hold 2 conferences within the space of 4 years without the permission of the branch, 1/3 of the branches. That must make this conference completely unconstitutional.
So you say 2 conferences within the period of 4 years?
Yes.
Where are the 2?
Well,
if you start counting after the last day of the 7th provincial conference,
well,
then the first one that was held was the one in November 2015.
No, my lord, I'm counting the 2012 because that's my first period. May 2012, that should have then lapsed in May 2016.
Yes, but you said there were there were then 2 conferences.
No, my lord, I mean there was only one conference which was held earlier than the 4-year period. It was the November 2015 conference.
So when do you say the 8th conference should have been held?
From May 2016.
What? Must a full 4 years have elapsed before it's held?
Yes, I submit
but
that...
But then there wasn't at least one conference within 4 years?
Yes, I submit that there must at least be a full 4 years because my construction of 1721 links with 1733. 1733 is quite clear that you are entitled to serve a period of 4 years once elected. Only question is how to compute that 4 years. That 4 years must be computed by reference to the civil method of computation. What's quite clear is that what they did was to reduce that term of office in a way that is in breach of both 1721 and 1733. And if I said 2, my lord, talking about the one conference in November 2015, that was the breach that I'm complaining about.
Well, I think the first one was, sorry, the seventh one
Yes,
was from the 8th to the 10th of May,
yes,
2012.
yes,
If I understand you correctly, you're saying the 4 years would then run from the 11th of May, 2012, until the 10th of May, 2016. Correct?
yes, ma'am.
And only after the 10th of May, 2016, would the 8th conference then be held.
Could it be legitimately held? Yes. Could it be lawfully held? Yes.
But during the period from the 11th of May 2012 to the 10th of May 2016, which is 4 years,
Yes.
there would not have been at least one conference. And it says here, 17.2, you know,
Yes.
shall be held at least once every 4 years.
Yes. This is the submission I make, that the conference in issue starts off in the 7th conference. The duration of that 7th conference lasts until the 8th conference can be legitimately held. So the duration of the 7th conference would be the starting point. When is the 4 years lapsing after that conference? That is the point that we make. And
Just take it back to the dates. The 7th conference finished on the 10th of May,
yes,
2012.
I must get the actual references to the record. But you
Well,
know,
let's take it hypothetically.
Yes.
Let's say it was from the 8th to the 10th of May.
Yes.
I have to check the date. The 10th had finished that afternoon. Now you start counting your 4-year period from the 11th of May.
no, my lord, we would have to count from the 8th of May because that's the start of the conference.
Well, that's where that's what I tried to clarify earlier on.
No, my lord.
Does it start?
The start
You
is the
start
8th
counting
of May.
your 4 years
Yes, yes.
at the beginning of the 7th
The
conference.
because that's when it's convened, yes.
Yes.
And then the next conference will obviously be, if we start on the 8th, then we will
No,
exclude
I understand that, but
yes.
why start at the beginning of the 7th conference and not after the 7th conference is finished?
But my lord, we are challenging here the convening of the conference. That we say that conference should never have been convened. So one cannot start in the middle of the conference, one must start when it begins, which is the first day of the conference, when they declare that we've met the constitutional requirements. In our submission, in circumstances where they haven't met those requirements. So the correct calculation would be from the 8th, which is the start, and then we can move to
Expiring on the 7th
expiring on
of
the
May
7th.
2016.
Precisely. Yes, that is my submission.
No, I understand that. I'm just puzzled as to why you start counting from the beginning of the 7th conference as opposed to starting after that conference was held and concluded and saying now we work out 4 years and you must have it within that 4-year period.
But my lord, we have to start when the conference is convened, because that is when they decide that the conference can legitimately be held. Because once one starts when the conference has been finished, the problem is that this conference should not have started at all. Because the fundamental problem was that it started without compliance with the ANC Constitution.
Yeah, well, that's the 8th one,
Yeah,
which would be the second one within 4 years
Yes,
if you
exactly.
start counting from the 8th
precisely.
of May 2012. If
Precisely.
you start counting from the 11th of May 2012, then it's the first one
Yes.
in the next 4-year period.
Yes, I made 2 submissions about that point, my lord. I need to clarify them. The first is that the conference starting from the 8th, when it is convened, in other words, when it is proclaimed that the conference can start. Conference starting from the 8th, running up to the 7th, which is, yes, the way of computing it, running up to the 7th, you will simply be unable to have another conference there at all, because it would then amount to 2 conferences within a period of 4 years.
I understand that.
Yes. But I make another submission, my lord, which is that if one looks at 1733, regardless of how they have looked at it, they still violate 1733 because 1733 actually gives meaning to 1721. Because 1733 tells you the term of office. And you know, my lord, I made the submission yesterday about the ultimate purpose that the 4-year period refers to. My learned friend has not once disputed that that is the correct construction of the Constitution in relation to the overall purpose. And we can debate this further. Why does this Constitution refer to 4 years if the 4 years can be terminated willy-nilly at the instance of the NEC? There is no other reason why it refers to 4 years other than to say that those people elected must serve out their period of 4 years. And it can only be interrupted at the instance of the branches in this decentralized format. So we submit, my Lord, with the greatest respect, that what we have here, we're applying for sheer from the start of the conference. We clearly have 2 conferences that have been held. What we also have here is that we have a provincial elected conference, so the provincial elected executive that did not serve out its full term. There is no justification for this breach. They say we had good reasons for doing it because we were trying to make sure that it doesn't coincide with the local government election. And then they criticize Mr. Senzo Mtunu for having been spearheading the decision to call the conference. Legally speaking, none of those are relevant. What is crucial is that they did not comply with their own contract. And that we submit with respect is in fact the kernel of this entire problem. And once that is appreciated, then the entire case falls flat, because then they must go and start afresh. Now, our learned friends...
Sorry, Mr.
Justice.
Before you move on, do you understand the construction that you place on 17.2.1?
Yes, madam.
Is that the conference should not be held within 4 years?
Yes.
It's only on...
A second conference, yes.
Yes. So anything before the 7th of May,
yes,
on your argument, would violate 17.2.1. Is that what
if not approved by a third?
Yes, no, except that latter
Correct.
part.
That is my submission. I think we've got... I've provided this morning with, yesterday and this morning with the authorities in support of the construction that we place on that very point. The significance of that point must now be obvious. If there was a non-compliance with such a fundamental provision of the ANC Constitution, it matters not that the NEC approved it. Incidentally, the only power that our learned friends seem to be able to refer to is clause 12.1, the authority to approve this conference, because there is, of course, no direct provision in the ANC Constitution that entitles the NEC to approve it. But I made the submission I made earlier that any power that the NEC might have had is restricted by the Constitution itself. So absent that 1/3 of the branch approval, there could have been no conference. Yes. Now, that relates to the third submission that I wanted to make. What that leaves us with then is the allegations around the question of delay. It's not clear what my learned friend's actual complaint is in relation to our reference to President Zuma. Because in paragraph 106 of the founding affidavit, what appears there is that President Zuma was here. He's the president of the ANC. He's, of course, the leader of the delegation. Together with Jesse Duarte, Joe Patla, Secretary General Gwede Mantashe, Baleka Mbete, Mcebisi Skwatsha. What they said appears in paragraph 166. They told them that they will get a decision within 5 days. What then happened is in paragraph 167. No response within the period of 5 days, notwithstanding that the president himself was part of the delegation that made the promise. What we see, how that is answered, is in paragraph 452 to 457 at page 1110 and 1111. There is no denial at all that President Zuma was here together with other members of the NEC. No denial that they told my clients that they will respond to them within 5 days. No denial that they failed to respond within that period of 5 days. So it's not clear what the complaint is, because the criticism is entirely justified on the papers. The next thing, in paragraph 169, what we say is that there was a letter written to the Secretary General, Gwede Mantashe, responding to the petition of 16 and 30 November 2015. So again, not only did they speak to the NEC as led by President Zuma, they also wrote to the Secretary General in a petition. Then there was no response to the petition. Then the Secretary General says no in paragraph 170. This is what he said, somewhat disgracefully. The Secretary General's written response was to advise those attorneys that the ANC does not deal with and reply to attorneys in matters involving its members. Then the report by the Secretary General is annexed. Again, if you look at pages 1110 to 1111, that is not denied. Now you get this really perverse point that is being pursued. And Justice Chetty actually pointed this issue to our learned friends. The NEC says, I'm setting up a task team to look at the irregularities that you are complaining about. Never sets the task team up, or if it did set it up, never gives a response to my clients. My clients wait for the highest officials. They write to the Secretary General, no responses. Eventually, what happens is that in May 2016, there is now an endorsement of this new PEC, because what they do in relation to that endorsement, they induct them. They call it an induction. At that point, it's clear to my clients that this thing is a game. It is not being taken seriously. And so the only way we can assert our rights is to come to court. To now say to those people, in those circumstances where promises are made and not fulfilled, that nevertheless they should be prevented from coming to court, we say is an utter injustice. What also is illustrative of what our learned friends have been saying about this point, you know, my lord and my ladies, they say, no, the NEC could not have done anything about your complaint because there is no prescribed appeals procedure. But on the facts, it is common cause that the president himself, together with the Secretary General, these two most senior officials, promised my clients that they would respond to their complaints within 5 days. Were they not telling the truth? If today it will be submitted in court that in any event the NEC could have done nothing about the complaints of my clients, what about the allegation that my clients make that in fact the NEC once dissolved a eThekwini region precisely because of irregularities? And we see that allegation page in the replying affidavit, page 1595 and 1596. 1596 in particular, 5th of March 2015, national officials decision. The Secretary General engaged the provincial officials on 27 February 2015 on the decision of the national officials and later summarized the decision as follows. The conference of eThekwini region has to be rerun within the next 2 months, ending in April 2015. Now, we know as a matter of practice that the NEC, or at least the national officials, can dissolve a regional conference. My clients say there are so much irregularities that this thing cannot be free and fair. They ask the same NEC to look at it. It promises to look at it. Then they eventually come to court. They say, no, sorry, you've been wasting your time. We submit with respect that this kind of approach that has been taken by the ANC respondents will simply not be countenanced. It's simply a stratagem to prevent the proper ventilation of my client's case before this court.
Okay, just going back to the point made by Mr. Harper, he said come day 6 and you haven't had a response. Nothing further was done. Do you just want to deal with that point?
I submit
Why wait until May?
Yes, well, until April when we actually started writing. I submit with respect, it is an unrealistic expectation because this is a political party. It is entirely unrealistic that my clients are expected to treat it as if it is a legal machine. One must act in good faith and expect that these undertakings will be fulfilled. What is clear is that there seems to be no good faith on the other side, because if they didn't have a response by the 5th day, there was nothing stopping them from telling my clients that we are still deliberating on the matter, you will get a response in due course. The most astonishing thing here is the fact that there is a total dead silence when my clients know that the expectation is within 5 days they would have responded. So it cannot now be turned around and my clients be accused of not having acted on the 6th day, because that simply would have been too soon. They obviously had to wait for a reasonable period to lapse. The signal came to them, and even in April 2016, they were still saying, you remember that you promised us to respond. We are still waiting for a response in good faith as members of the ANC. The signal that was decisive, the turning point, was in May 2016, when they then decided to induct the PEC. It was not inducted for a period of 5 months, 6 months. When they decided to induct the PEC, then it became clear to my clients that these promises that were made are not going to be fulfilled, and that if we want justice, we should go to a court of law. So we would submit with respect that it would be grossly unfair to now non-suit my clients on the basis of delay if one has regard to the specific facts that are alleged in this case. My lady, it's 1 o'clock. I have only one more point, and then my learned leader will deal with the remaining aspects.
How much time do you think you're going to take? Because we could go on. Alternatively, we adjourn and come back at 2. So if you give us some indication how much time.
Usually it's quicker to get an adjournment so that you confine your thoughts, so that it's shorter. So it's
Okay.
so
We'll reconvene at 2.
thank you, my lady. Let's discuss now what we're going to do with it, because I mean I'm probably another 10 minutes and then that's it, and then we're going to deal with these things. Hey Greg, this is your beer, man. Greg, this is your beer.